So, kicking things off, by far one of the most common questions or objections we get from clients is that they're saying that they've already had their professional advisor, such as their lawyer or their accountant, to look at their employment contracts and other documentation in the past. So, based on this, they ask us why they should pay someone like On Demand HR to do it all over again. Do you have any thoughts or insights on this?
Yeah, good question, Andrew. In my view, generalist lawyers and accountants do not have the specialised knowledge in the HR and employment contracts sort of space. And in their profession, they do not work with the mechanics on a daily basis. They have other competing priorities that are more aligned with their profession. So they may not put meticulous detail into supporting the business in the way that we do when working directly in the specialist space. I would ask any business about their contracts and how long it's been since they've last reviewed them. In the last so many years of the employment relations legislations, we've had the most amount of changes just within the last 2 years alone in this sort of space. So I would ask, are their documents up to date? When were they last looked at? And is there anything irrelevant in those contracts, or are they hard to understand and read with a lot of jargon that your employees wouldn't understand? Ultimately, it's about ensuring that these documents suit business's best interests, that they're easy to understand for their employees, so that when they're needed and called upon, they can be easily understood.
Yeah, I think that's a really good point around, inclusions of clauses and in the employment contract that are not necessary. And quite often, I don't know what your thoughts are on this, but we see particularly lawyers, if I'm honest with you, that don't have that specialized knowledge. They include a lot of additional clauses that create some additional obligations on the business. For example, putting policies and procedures clauses inside employment contracts. Why do you think that that's a problem?
Well, when it comes down to the employment contract, you want it to be securing the employee to work for the business. That's basically what the contract is. It's about the mechanics of master-servant, basically the engagement to the business. But if it's restrictive on the business's way in which it operates, it's going to obviously make operations harder when they need to change policies that are in their contracts. If the contract says that it's got to be done a certain way or a certain step, this policy or procedures in place, then the business can't change it unless the employee unilaterally agrees to change what's in their contract. Alternatively, if a business was to change things and not consult the employee, they could be themselves breaching their own workplace standards, and again could bring further difficulties to the business in trying to repair something that could have been easily sought after if it was in a handbook or a policy manual, so to say, rather than a contract itself.
Does your business currently have a HR or workplace relations issue?
Are you unsure how to work through compliance issues but still achieve a good business outcome?
Why not take advantage of On Demand HR's free 30-minute online consultation with an experienced HR consultant?
At the end of the consultation, we also provide you with a strategic action plan to resolve your current issues.
To see the types of matters we can help with and to schedule your consultation, please visit ondemandhr.com.au/advice.
We look forward to delivering certainty, confidence and clarity for your business in your HR and workplace relations affairs.